My name is Jeremy Poock, and I lead Senior Attorney Match. In today's In 7 Minutes, we'll discuss the third in a series on the 3 checklists to consider when considering to sell your law practice. The third checklist that we'll discuss is the rules of professional conduct that intersect with selling a law practice. So let's jump right into it. When it comes to the rules of professional conduct to consider when considering selling your law practice, the first rule to consider is Rule 1.17, sale of a law practice. Let's take a look at the ABA's Model Rule 1.17. Each state has adopted a version of this, and we'll look at the Massachusetts version in just a moment. I'm in Massachusetts, but again, every state has their own version of Rule 1.17. This rule, as many of the rules of professional conduct are, is very client centric. So the rule will focus in particular on Rule 1.17c. This part of Rule 1.17 requires that a seller give notice to each of the seller's clients regarding the proposed sale. And it gives the clients a notice that they can pick up their files within 90 days of receiving that notice of the proposed sale. And if clients cannot be notified, then lawyers are compelled to go to court to have a court approve the sale of the business with sale of the law practice with regard to those clients who the lawyer is not able to notify. In the model rule, in A and B of Rule 1.17, there's additional aspects that actually require that either the entire or a part of the practice be sold and that a lawyer cease from practicing after selling the law practice. Now let's take a look at the Massachusetts Rule 1.17. Massachusetts, unlike the model rule, does not include the requirement that a lawyer cease practicing altogether, but does maintain the requirement of that notification to the seller's clients about the proposed sale and that the client has the right to pick up his or her file. From a practical standpoint, Rule 1.17c, for as great as it is from being client-centric, is impractical from the standpoint of lawyers considering selling their practices. And the reason why is we'll take a look at what are the 5 components of valuing a law practice. When it comes to valuing a law practice, there really are these 5 components post 2020 of the client list, the referral source list, goodwill that a senior attorney has developed over the course of his or her career, the subject matter knowledge that they've developed, and their digital value. Well, the client list is really of utmost importance. And when it comes to Rule 1.17, if a senior attorney needs to notify his or her clients in advance of the sale that they're considering selling the practice to a potential buyer, we view that as a potential lose-lose-lose. That is, you could lose clients by sending out that notice. You could potentially lose your buyer because if the buyer then learns that significant clients have decided to actually pick up their files and move on to third-party lawyers, then you could lose the buyer. And then the third loss in this lose-lose-lose is then you've lost value because a primary component to value when it comes to valuing law practices is the client list. So what's the alternative? Our preferred option outside of a Rule 1.17 sale is that senior attorneys join growing law firms, and that when they join those growing law firms, they do so either via a merger or via a recruitment. That is, a senior attorney and attorneys at the senior attorneys' firms are literally recruited into a growing law firm, and that growing law firm recognizes that the senior attorneys have what the growing law firms need and want. They have the clients, they have the workforce, trained workforce that senior attorneys often have with other lawyers and support staff, the cumulative experience that senior attorneys and their staff presents, and tremendous marketing value. And it doesn't necessarily need to be sold via a Rule 1.17 sale. And when senior attorneys join growing law firms and they're able to continue practicing there, because as a reminder, in Rule 1.17 in certain states, there's actually a requirement that the senior attorney cease practicing. Well, again, going back to the practicality, we'll show next the trust transfer. This is what we call the flux capacitor in the senior attorney match model, which is that when senior attorneys join growing law firms, they're transferring the great trust that they've developed with their clients and the referral sources over many, many years, and transfer that trust to the lawyers at the firms that they join. And it's really necessary for senior attorneys to stay on, for them to be able to experience the value that their practice presents, to transfer the trust of their clients to the firms that they join. And for the firms that they join, they really need those senior attorneys to stay on as compared to ceasing to practice altogether. There are additional rules to consider when it comes to selling your law practice, and the next rule is Rule 1.5, which deals with fee sharing. So we're all cognizant of the Rule 1.5 aspect of when we're making referrals to third-party attorneys. Often that happens in the personal injury arena, and it happens with other lawyers as well. Most states have within their Rule 1.5 a provision directly in the rule or in the comments that provide for fee sharing with lawyers who are formerly in your firm via a form of a separation agreement or a retirement agreement. And that can be a tremendous basis for how to set up fee sharing over time when lawyers join growing law firms, retire from those firms, and then can fee share with those firms per that portion of Rule 1.5. Next rule of professional conduct to consider is Rule 5.4. 5.4 sets out the professional independence of a lawyer, which includes the prohibition against fee sharing with non-lawyers. There are exceptions to that, and the primary exception is twofold. Number one is when there's a sale of a law practice per Rule 1.17, and a lawyer has already unfortunately passed away or passes away during a payment period. There's an exception in Rule 5.4 to fee sharing with the personal representative of the estate or other designated representatives of the estate. The other exception is when there's an agreement between a firm and a lawyer dies while practicing at that firm. So Rule 5.4 is certainly important when we're thinking about succession planning and selling a law practice. Next rule is the rules about confidentiality. When you're considering selling your law practice and discussing the clients of your firm, how much client information can you actually share with a potential buyer about your clients? So we definitely recommend that both sides, sellers and buyers, review Rule 1.6 regarding confidentiality. Next rules are Rules 1.7 through 1.10. These relate to conflicts of interest. There can be great synergies between law firms, but if there is even one conflict or numerous conflicts, the lawyers really need to consider that. They need to flesh it out. They need to potentially notify clients. And we've had deals that have been either totally put off, that is, they just couldn't go forward because of the conflicts of interest, or delayed significantly because of the duty that lawyers have to their clients with regard to these conflict of interest rules. And then the additional rule of rules of professional conduct to consider are Rules 7.2 and 7.5 relating to advertising and firm names and letterheads. And here we'll show the Massachusetts version of Rule 7.5 with regard to firm names and letterheads. And this is really not only about the present, but it's about the future. We're seeing more and more in the marketplace that, number one, law firms are adopting trade names. We just wanted to point out that the rules in most states permit lawyers to practice under a trade name. They also permit lawyers to have websites that don't necessarily contain the same name as the firm name. And the comment in Rule 7.5 indicates that those types of communications, that is, whether it's the website communication, the trade name, and also the use of a retired attorney or a deceased attorney's name, these are permissible so long as they're not misleading. And so when the negotiations are happening between seller and buyer, and I'm saying that this is both present and future, is that as we're heading deeper into the 2020s and law firms are starting to develop brand value, and as we are now in the 3.0 digital era for law firms. More and more firms will have real brand value, and Rule 7.5 is a very important rule, and the rules under Rule 7 are very important in terms of what is going to be the value of a trade name, the value of a firm of a firm's name, and how a purchasing firm can utilize that value going forward, albeit without misleading the public when doing so. And that is today's state of the market for law firm sales in a bit more than 7